that when you're appointed, people need to realize that when you're appointed an
She's
attorney,
working against me, you're working against me, the district attorney is working against me, and you're not listening to me.
Yeah.
And everybody hears me. Hey, look, now they're gonna assault me.
We're not assaulting you, we're just.
Yeah, you don't need to do that.
There is no complaint.
Your Honor.
No. No, what do you want to say? We're here to listen because you keep interrupting your counsel.
What did you not hear?
I didn't hear any of it.
Why not? Everybody heard.
No, they did not.
You didn't hear it.
No, they said they did not. So you want to talk to her? She's right outside.
You went outside. You're sitting right there.
The court knows sometimes the state has to step in to protect.
Nothing happened.
No, what I am telling you is, and this is the problem. I don't know why you won't listen. That's part of your problem. You don't listen. So his pretrial services officer is not available. The person who's come to testify will be Giovanni Martinez.
Yes, ma'am.
Thank you. The defense has said they're going to object to hearsay because he's not the pretrial services officer. And what I can tell state, I would sustain that objection. So this is what the court is going to do. And Mr. Martinez,
Yes, ma'am.
the court is going to alter and amend his conditions to full GPS.
Yes, ma'am.
You're going to be on full GPS. So you're not allowed to leave your home.
Your Honor, with regards to employment, if the court were to modify it to full GPS house arrest, my client would unfortunately lose his job and then at that point lose his ability to afford the house he's currently in.
Well, what he needs to do is he needs to provide adequate proof that he is employed and where this employment is located, and then the court will reconsider.
Okay, Your Honor.
So he'll need to provide that. And what I can tell you, if you provide that, I'm not trying to make someone be unemployed or not have funds, but if you provide that, then the court will strongly consider allowing you to work on GPS. And let me explain to you what the court's problem is. The court problem is that the report is stating that you are not abiding by their rules and that they've told you before, these are the rules. You have to abide by the rules. I always tell everyone who comes in this court, if there's an issue, then we can come in and we can address that before we get to this point. And this is your second violation report with the court. Normally, we can go off the record. Normally, you know what other courts usually do? They just go ahead and rule on this. There would already been a warrant for your arrest based upon the nature of the offense. And the problem is with the nature of your offense, they have to know where you are located. I'm not the one who puts you on GPS. A magistrate judge or some other judge puts you on GPS, not me. But the rules that judge put in place for your GPS are the rules that I follow. Now, if it comes to a point in time where someone wants their GPS removed, or if they want a curfew or tracking or something else, that's something else we can discuss. What I can tell you in this court, asking for forgiveness instead of permission is not a good way to go. So all you had to do was come in and say, this is what's going on in my life. Can we modify GPS? And sometimes the state will agree on the modification. Sometimes they will not. But what I can tell you is if the state and the defense can't come to an agreement, I'll listen and I'll make a decision. Maybe I'll agree with the state's assessment, maybe not. Maybe I'll agree with the defense's assessment, maybe not. And then sometimes when states and defense, when you all have agreements and I don't think it's appropriate, then I don't agree with it. I don't do it. So let me just tell you what I need from you so that we can be clear. You will need to provide proof of your place of employment, and you will need to provide the hours that you work. And only then will I consider partial GPS for employment. And at that time, what I can tell you, it will be for employment only. You understand? Because I have to act when there is, based upon the nature of your offense, and there are these violation of GPS inclusion zones. And really, it's for your best too, because the complainant could say, you know what? This is where I was and I saw him. Or this is where I was and I saw him. You don't want that to happen. You understand? Yes.
There is no complaint.
Mhm.
There is
Yeah.
no complaint. There is no complaint.
Your Honor.
No.
Stop. I'm done.
Thank you.
Unless I speak about something else.
No, it's just.
Let me explain something to you. You're saying that there is no complainant. I don't know anything about the facts of your case. You know why? Because nobody has presented facts of this case to me. All I know is what you're charged with, and what you're charged with is continuous violence against the family, right? So when there are charges, continuous violence of the family, robbery, murder, whatever it may be, the state, in some cases, you're saying that there is no complainant. There may not be a complainant that's going to come to court, but a complainant exists. Although we have had a case indicted before, none of these prosecutors indicted it without a complainant. But normally, there's supposed to be a complainant. And in your case, looking at the indictment, there's a complainant listed. So there is a complainant. Whether or not that complainant is coming to court or not, that's something for the state and the defense to worry about. I'm just here on this violation report. And what I'm telling you, other judges, and in the past, defense attorneys will tell you on these violations report before I took the bench, you know what previous judges would do? Just do a bond forfeiture or do an increased bond or remain without bond, and you will be brought over in orange. So what I'm telling you is you're going on full GPS. Your officer knows that it's going to be full GPS. Counsel, if he has employment, he needs to provide the hours and proof of employment to pretrial services. And then I will consider whether or not I will allow him to work while on GPS.
Yes, Your Honor. Well, if I may, he has provided that proof to the pretrial service officer who's not here today. I will have him email me that information again
Mhm.
and provide that to the court coordinator as well as directly to Mr. Martinez.
Well, and you all should ask Mr. Martinez if he has that. If you want to find out from Mr. Martinez if he has proof that he's employed and what his hours are, then
yes,
I'm assuming there will be no objection to hearsay.
no objection at that point.
State, would you have any objections to Mr. Martinez?
No, ma'am. I'm pretty sure Officer Bohack has got full credentials and everything. I'd be more than happy to provide him with his attorney. Just need a contact information. I'll send it to him right away.
Okay.
All right. We're also here because he said today, where are we on discovery?
I didn't realize we were already set. Your Honor, I believe we received the discovery on one of the altercations. The other altercation I need to get with the state. I didn't realize it was actually set for today.
I figured since you're already here, so
Yes.
that way he won't have to come back.
I will get with the state and confer with them about some additional discovery I do need.
All right.
We'd ask, I guess, at this point, for a 30-day reset on the actual case.
Okay, just 1 second. Let me go. All right, let me just explain. I'm a little bit confused by the document. Or maybe I'm interpreted incorrectly. All right, state, do you agree that the hours he works are from 9 a.m. to 8 p.m. Monday through Saturday?
I mean, I don't agree, Your Honor, because I don't know. My understanding was that was his personal business. Is that?
Is this your personal business? And what do you do?
Like think of Geek Squad.
I'm sorry, what?
Think Geek Squad. I'm a computer guy. I repair computers. So I have a PO box where I go pick up computers and I go to people's houses and I knock out computers, whether it's businesses or computers, and not to mention that I work for another company that does ATMs. So I do Rocket Criminal, which is Bitcoin ATMs. So
I'm sorry, you need to speak up.
I also fix ATMs. So you think like I'm not sure if you know about Bitcoin, but Bitcoin ATMs, that's what that is as well. So I have a contract with a company that does Bitcoin ATMs where I have to move That's the reason why I'm asking.
All right, so what I can tell you is, one, I didn't know this was your own business. This 9 a.m. to 8 p.m. doesn't work for the court. I'll allow you, well, I mean, this is what I'm telling you. I'm not doing 9 a.m. to 8 p.m. and 10 a.m. to 8 p.m. I'm not doing it because the hours that you're posting, these are hours that you say. I don't have any proof that this is actually occurring. All I have is your word saying, I'm going to a PO box to pick up computers. And I do this from 9 a.m. to 8 p.m.
And I also look at houses.
Well, again, this is from 9 a.m. to 8 p.m. I don't have any proof of that. All I have is you're saying it. And I'm not going to agree to a time from 9 a.m. to 8 p.m. That's more than 8 hours a day.
Your Honor, an alternative, my client would be able to limit his hours to a traditional 9 to 6, 9 to 9, or I guess it would be 8 to 6, just to give him that window of being able to travel.
I'm not doing, I'm telling you, if I allow him to do this, it's going to be normal business hours. It would be 9 to 5. And even when I'm doing it 9 to 5, he needs to have documentation that he actually went to a PO box. The time he is going to that PO box, he needs to provide it to them.
I don't know how. Just going to the box, I'm supposed to. This is the problem that happened with the GPS officer in the first place.
So here's the thing. This is what I'm telling you.
I'm not trying to be.
And no, I don't take it as being difficult. I understand that you want your hours to 9 to 8 p.m. The state is saying they don't want you to have it at all. I understand why the state is saying no, because you're on bond for continuous violence against family, violation of bond or protective order, assault and stalking. So here's the thing, whether it's true or not, I don't know. All I know is what your charges are. All I know is my job is to protect the community. All I know, at least one of them, all I know is your attorney is saying that you can't pay for this GPS because you're on full house arrest. So this is what I'm sorry.
I can't pay for anything right now. I'm about to be homeless.
Yeah.
This is why I need to work.
All right. I will tell you this.
I need to work Sundays too, and I need to. And if I'm
Well, that's not going to happen. I would-
Your Honor, if we can ask that it be modified to the 9 to 5, my client will provide the necessary proof at this point. If that is the court's order, he will abide by the court's order. And I will make sure that he understands that that is the court's order at this. It is better than nothing at this point because he does need to get to work, Your Honor. He is going to be homeless soon if he cannot start making, money. He's made current arrangements with his landlord to allow him to stay there. But he is behind, I believe, a month or 2 months behind rent already.
I need to leave. He's already given me a termination on my lease, so I need to get out of there. So I gotta be able to generate something. And maybe I was asking for just tracking only so that I can move around.
No, tracking is not going to be allowed. That's not even a consideration.
Can I speak? I don't know.
You can speak, but I'm telling you.
No, I'm just gonna ask a question.
Sure.
I'm asking a question. So I was told the other day by the DA that I'm gonna listen to you. I'm not gonna talk.
No, I'm listening. Go ahead.
I'm not gonna talk.
No. Here's the thing. I will tell you, I keep an open mind. The issue that I have with you is that the timeframes he's asking for, there's too much of an open window. And basically, if I allow him to do this, it is sort of like tracking because he's saying he's working from 9 a.m. to 8 p.m.
Yes, sir.
I don't know if he's going to a PO box or whatever. Somebody would have to ask the
I'm not gonna go
pretrial services to do that.
I need to generate money.
Your Honor, if we can, like I said before, we are willing, if the court is only allowing him to work from 9 to 5, my client will make the necessary arrangements for his business to be able to work within those hours that the court allows. We are asking that it be modified to allow that at least.
He will just need to have to modify his hours at that point.
All right, so this is what I'm gonna do, and I want you all to write this up and state, I know you're not in agreement with it, but I'm gonna want this written up. So his hours that he's allowed to work are from 9 to 5. That includes going and coming. He is going to have to pick a specific time when he is going to be traveling to go to his PO box. And he needs to put down the location of the PO box. And in these hours from 9 to 5, Monday through Saturday, he needs to put in the order the time in that block of time that he is going to be traveling to his PO box. And if somebody calls him and they want a computer repaired, he needs to call pretrial services to let them know, I've received a phone call. This is the specific address that I'm going to either pick up a computer or repair a computer at this address. And he needs to tell them how long he's going to be at that address.
Speaking,
Yes.
how about when pretrial don't answer because they never answer?
Your,
I can't even speak to my pretrial officer. He
Send an
doesn't-
email.
your
I
Honor,
have proof of all the emails I've sent to him.
Well,
Your Honor, if I may,
Mhm.
if I may, I understand the court's order. I know he needs to give documentation. I know he needs to tell them that he's gonna go. But sometimes, as he is saying, there is time constraints of when,
I'll just put it in an email. It's a paper trail.
of course, Your Honor, so he wouldn't need confirmation from them to say, yeah, you can go there. It would just need to provide documentation of proof. This is where I'm going.
This is what the court's order is. He needs to sit down with you. And for each Monday through Saturday, his time he's allowed out is from 9 to 5, and has to be work related only.
Of course.
So for example, on Monday, if he says, I'm going to go to my PO box at 10 a.m. and he needs to pick that date, not I'm going at 10 a.m., then I'm going at noon. No, just pick one block of time that he's going to his PO box. In the order, put, defendant is allowed to go to his PO box on Mondays at, if it hypothetically, it's 9 a.m.
Mhm.
At 9 a.m., the PO box is located at this physical address. He's only allowed to be there for no more than an hour to get whatever he needs from that PO box. Now, mind you, sometimes people are standing in line. It's something that the postmaster who's in charge of that location has to give it to you. That's fine if he goes beyond that point, but at least the GPS will show that he's at that location at his PO box.
Okay.
So he's only allowed to go to that PO box once a day, pick whatever time he wants to pick it. And then if he has somebody who calls him and says they need a computer repaired at their home, he needs to get that person's address, email or call GPS and said, I'm going to go repair this person's computer. This is the address.
Okay.
And when he goes to that address, when he gets ready to leave from that address, because the GPS should show I'm at 300 De La Rosa and I'm still here repairing a computer. When he gets ready to leave from repairing that computer, he needs to send them an email and said, I've completed repairing this computer, or I'm leaving this location, and then he goes back to his home.
Okay.
So if y'all can,
Can I stop and get something to eat?
no,
I can't
Just
stop
for
and get
work.
something to eat.
that's what Uber, don't they have Uber Eats or something else that happens? They
And who
have
can afford
delivery.
that when I can't work?
All right, let me just tell you, here's the problem, and I want you to internalize what I'm saying.
I am.
No. I mean, seriously, internalize it. I do not take any of these charges against anybody as true. I don't take it as beyond a reasonable doubt because I haven't seen any evidence. But my job in this part of the process is to make sure that the community is protected. Part of your problem is you're charged with continuous violence against a family member. You're charged with violation of a bond or protective order. And when you have a violation of bond or protective order and it's in felony court, that means that there are extenuating circumstances against that. That means that somebody allegedly has told you before, this is a protected class of people, you're not to be around them, and allegedly you violated. Then I have assault stalking.
They
so-
violated. I didn't
so-
violate anything.
Here, then we have this assault stalking thing. So
Yes, sir.
that person will be very concerned. And so, do I consider the complainant? Yes. Because at the end of the day, the complainant, whether what they're saying is true or not true,
Sure.
they don't want to end up at some store and then all of a sudden they see you.
If I can give some context, just on my client's behalf, because I know he's wanted me to say it at this point.
Sure.
Is that the complainant has submitted two different, I believe, affidavits or statements to the DA's office where she has recanted her story, as well as the modification has been modified to a no harmful or injurious contact.
Mhm.
So I believe my client, I think what he's trying to get at is, when we were talking about tracking, or when we're talking about the GPS, I think his position or our position is that there wouldn't be I guess, harm to the community because the complainant is on board with him working and getting to.
Well, let me ask you this. Have you
Wait,
received
she's
all
right
this?
outside.
Have you received all discover? Do you want to talk to her? She's right outside.
She's right outside. She's sitting right there.
The court knows sometimes the state has to step in to protect the community.
All right, so this is what we can do. We can set this for trial next week if you all want to trial. I'm here. You're here. The state's here. I can put it on
I
trial.
believe we're close to an agreement. We've been conferring on the matter
All
already.
right, well, I mean, if you all want, I'll call you back May 13th for a jury trial. You can either do a jury trial, bench trial.
I'm not
Let me
scared
explain.
of that. Nothing happened.
Now, what I am telling you is, and this is the problem, I don't know why you won't listen. That's part of your problem. You don't listen. Now,
don't even
what
know.
I'm telling you is, I will bring this back on May 13th. You can either have a bench trial or a jury trial. Will you be ready for jury trial on the 13th?
Your Honor, there is another,
There's another case, Your Honor, we are trying to, we're close to wrapping all of his cases up in a global offer. We would just ask that the court give us some time.
on May 19th, Your Honor, when we're coming back, on that day, we will have the answer whether
Right,
this
but-
is going to be a plea or a trial.
But
date.
what's the other trial?
Thursday, right, Your Honor.
All right, so then I have that to work with. So this is what we're gonna do. We're bringing back this on May 13th. That'll be your jury trial date. You can, the witness can come, not come, whatever is gonna happen. May 13th, jury trial.
Thank you, Your Honor.
All right, thanks. Ms. Ferguson, give them a date for jury trial, May 13th. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we'd like to.
Anything you wish to say on behalf of your client?
Yes, Your Honor, I'd like to just, if we court follow the current plea agreement, the 1-year deferred adjudication drop down to the VPO. The state is aware that the complainant in this case has made contact with them. And we've also submitted sworn affidavits to where she had recanted the allegations, all of which, except for the fact that he did make contact with her on that date in question, which I believe was the October date. For those reasons, Your Honor, we'd ask that the court did follow the plea agreement, as well as a condition of probation to include just a no harmful or injurious contact with Sophia Barnes, because they are still dating and they are together.
Do y'all have any children together? All right. And then my other question is, he's on GPS, correct?
Yes, Your Honor, we're asking that be removed as well.
State, do you still want him to be on GPS? There's to be 1 year deferred adjudication, $500 fine probated. This will run concurrent with 2025 CC 006406. There's to be no contact with Sophia Yvette Barnes.
Your Honor, with the no contact order, I believe that's who he's currently residing with. So I'm
I hope he
asking.
hasn't been residing with her while he had this case pending, because that's a violation as well.
Well, the bond conditions have been modified already due to the affidavit and the statements made to the state's office. That bond modification was, I think, occurred prior to the case even being indicted. And it was indicted to a no.
Well, what I can tell you is I don't lift no contact orders unless the complainant comes in and speaks with the court.
So that's my question. If she were to come in, and then would the court be open to have the?
Yes,
I guess.
I'll listen to her and make a decision.
Okay.
All right, we're going to go on the record in 2023 CR 8695, State of Texas versus Paul Anthony Perez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Pettis.
Are you Paul Perez?
Yes, ma'am.
Your attorney has filed a motion to withdraw. Are you aware of that?
Yes, ma'am.
All right, what's the purpose, the reason for withdrawal?
Your Honor, there's a conflict of personalities. Mr. Pettis had communications that haven't been very fruitful and continue to go downhill from there, Judge. And from my conversations with Mr. Pettis and his family, they're attempting to hire an attorney, but the one thing that they are certain of is they do not want me to represent Mr. Pettis.
All right, so Mr. Perez, this is your attorney until your family hires one. And this case is going to be moving whether you hire an attorney or not. Do you understand?
Yes, ma'am.
All right, so the motion to withdraw is denied.
So, I couldn't get another attorney?
No, this is your attorney.
Oh.
Let me explain something to you, and we can go off the record. The way things work, there are attorneys who have been approved to handle certain levels of felony. Your case is a second-degree felony. This attorney has been appointed. You don't get to go forth and say, let me just shop and pick the court-appointed attorney I want. That's not the way it works. You understand?
Yes, ma'am.
Right. This is what I've discovered. I've been a defense attorney. I've been a prosecutor. Clients that I've represented, sometimes they get upset with me. You know what they would get upset with me about? Because I'm not getting the offer that they want the state to make to them. State can make whatever offer they want to. You can think it's ridiculous. I encourage people not to use the term ridiculous because then that's not being kind. So if the state makes you an offer and you don't want to accept it, your attorney will say, this is the offer the state is making. And you can say, I'm not accepting that. And then guess what? He'll go back to the state and he'll say, he's not accepting your offer. Or the state will make an offer and your attorney will tell you that what the offer is. And you will say, you know what? I want to accept that offer, but this is what I will accept, which is called a counter offer. So you are rejecting the offer that the state has made and you're asking for something different. Now, when your attorney goes to the state with your counter offer, if you make one, the state can think in their mind that's ridiculous and say, no, the only offer we're making is what we made to you. That's how it works in here. And you can either accept it or not. You can be upset that you didn't get the offer you wanted. I would have clients, sometimes they would be upset because they want their case dismissed yesterday. We are where we are. So your only choices are the state can make an offer. You can accept it or reject it. You can give them a counter offer or not give them a counter offer. And then if you all can't come up with an agreement, then it'll be set for jury trial. You understand?
Yes, ma'am.
That's the way it works. How old are you?
I'm 18.
All right. So yeah, you need to talk to your attorney. And whatever the state has in their file or whatever discovery, your attorney will go over it with you.
Can I tell you why I wanted to dismiss him?
Sure. If it's going to be something negative about you don't think, okay.
iPop SID number 117.
Oh, no. You don't have to read it as though you're reading a legal document. You can just tell me.
Oh, because
what is your issue?
I dismissed him because on my behalf, on the grounds that Mr. Sandoval is biased and has been neglectful of his duty under Article 2.03 and has failed to represent me in the way he is supposed to.
All right. So let me just tell you, he's here right now. State, do you have your file down here?
It's here, Your Honor.
Have you read the file?
The defense counsel actually asked me to review it and give an offer.
Okay. So there you go. He's representing you. What do you expect him to do with his representation? What do you specifically want him to do?
What do you mean by that?
I mean, you're saying he's not representing you. What do you want him to do?
Just, how can I say it?
You don't have to speak in legal terms. It's fine. You can just speak to me. Well, let me help you with here. Let me ask you this. Have you asked him or talked to him about what you want him to do or what you feel he isn't doing?
Right.
All right. So discuss that with him. And I guarantee you, if it's something legally or ethically he's not allowed to do, he will tell you, ethically, I'm not allowed to do that. And if that's the case, then that's the case. But he will talk to you. Mr. Sandoval, do you have any objections to speaking with him?
No, Your Honor, we visited several occasions over Zoom.
Yeah, he will speak to you. So you're here, he's here, you can speak to him. All right. Ms. Ferguson, on this case, can I have a 30-day reset, please?
I can do November 28th.
All right, we're going to come back on November 28th. If you all work out something differently, your attorney can request it and we'll see you sooner than that. You understand?
Yes, ma'am.
All right, thank you.
Thank you.
I do my best to remember everybody so that you will know that you're not just a number to me. And it's easier for me to remember faces and names as opposed to SID numbers. I had one client though, his SID numbers were 3 digits, so that was easy to remember. And you know what that means if your SID number only has 3 numbers.
Time ago.
Oh yeah, when I would go see him at the jail, the people at the jail, no, Stephanie. I'm like, no, those are his numbers. And then they're like, oh my gosh. So he had a case from, I think, 1960. So that is why he had the 3-digit number. Oh yeah? Oh, wow. All right. So, Mr. Bernal, do you want a jury trial or a bench trial? What do you want?
Judge, he wants a new attorney.
Oh, why?
I don't think she's surrendering my best interest. I'd like to hire her.
All right. So here's the thing. Let me explain something to you.
Rightly said.
Sometimes, and it's okay if you want to hire an attorney, that's fine. Sometimes people think an attorney is not working in their best interest because that attorney is not giving them what they want. Sometimes people want a dismissal and the attorney says, well, I talked to the state. State says they're not dismissing it. They can't force the state to dismiss a case. If you want a dismissal and the state says, no, we have enough evidence, we're not dismissing it, then your choice is, hey, either you accept that they're not going to dismiss it, enter into a plea bargain agreement, or either you go to a jury trial or a bench trial. But your attorney can't force the state to give you what you want. That's not really how it works. The way negotiations work is they'll go to the state. Maybe your attorney will tell the state, hey, I see some bad issues with your case. This is what you're going to have a problem proving. And then the state will be like, oh, I didn't view that. These prosecutors will do that. I don't know what other prosecutors are doing, but they're saying like, oh, I didn't consider that. Let me look into that. And then they'll probably look into it. And if everybody agrees on what they're seeing or what the issues is, they may say, you know what, we are going to dismiss it. But you're charged with the burglary of a building.
Right.
So burglary of the building cases, they're very simple. Drug cases are very simple and in terms of what needs to be proved. So if your attorney is not giving you what you want, which may be a dismissal, that doesn't mean that they're not working in your best interest. It just means that the state said they're not going to dismiss it. State, on Raphael Bernal, are you all going to dismiss this case?
We will not be judged.
So is there anything that the defense can do to make you dismiss this? I guess other than that you're on video at the picnic with the pastor or something. You know, I said there is nothing that she can present to them that is going to make them want to dismiss your case. They're saying they're not going to dismiss it. Is that correct?
That is true, Judge.
Is there any information that the state can bring you?
That defense could bring us?
Yeah, I'm sorry, that the defense could bring you to have you dismiss this case?
There is not, Judge.
So they're not going to dismiss it.
Okay, everything that you said prior to this about how she's not doing her job.
No,
Let's explain.
I'm not saying she's not doing her job. What I'm telling you is it appears that you, and I'm using it as a hypothetical, you want a dismissal. The state is saying they're not going to dismiss your case.
But she hasn't also given me the proof of why I don't have a case for dismissal. She's never given me. I need to look at the proof to see what proof they have to convict me.
All right, so let's do this. Could you go over the paperwork with him again?
Yes.
All right, and State, could you make sure that she has your file so that she can show him police reports and everything?
Certainly, Judge.
On the record, respectfully, Judge, I have shown him all of the documents that we have in the state's file. He's looked at the state's
Oh, no, here's the thing.
Yeah.
Sometimes.
We'll do it again.
Yeah, sometimes people go to the jail and maybe they forget certain things. I don't know. But she's going to show it to you today. And she's going to explain to you, according to the penal code, what burglary of a building is. All right. Part of it is going inside a building without consent. So that's part of it, right? No. Here's the thing. That's part of it. So she's going to go over that with you and show you what's in the police report, okay? And then we'll come back. But what I want you to know is when you're sitting over there, the state is saying they are not dismissing the case and she can't force them to dismiss it.
I understand.
Okay.
Fully.
Okay. All right. All right. Thank you. Just have a seat.
May I make sure, just on the record, he has made very clear that he does not want me representing him, that he wanted to retain an attorney. Do you still want me to
Oh, yes.
Okay.
I mean, do you have an attorney here today?
No.
All right. So yes, you're his attorney.
Okay.
All right. Thank you.
So I just don't want to complain. Yeah, she's ordered.
No, she is going to show you
Right.
all of the documents that the state has against you.
Okay.
And then once she's shown you that and you've read it, just come back before me, okay? All right, thank you.
Thank you, Judge.
Thank you, counsel. Mhm. All right, Jesus Santoyo, are y'all ready? Oh, Mr. Bernal?
No.
Hi. So you want a jury trial, is that correct?
Yeah, I was off for 8 months.
No. Here's my question. Legally, I'm not supposed to hear what plea negotiations y'all have made because legally those are supposed to be confidential.
Right.
So I'm going to wash my brain of what you just said. So my only question for you is, are you reaching an agreement with the state or do you want a jury trial? That's either yes, I want a jury trial, or no, I don't want a jury trial. All right, so here's the thing. We've been here on this train before. So the train stops here. Do you want to, if you want a jury trial, I will give you a jury trial. So do you
I'm
want,
a lawyer.
well, do you have money for an attorney? All right, then that's where we are. This is your attorney.
No.
All right, so you're going to represent yourself?
No, you can hire me another attorney.
No.
Judge, respectfully, I'm sorry. Can I speak to my client for a second?
Yes.
Mr. Bernal, can you step over, please? Step over, please.
Working here. No. She just said, they don't send you to prison just because you don't have money. I don't have money, I need another attorney.
All right, let me
Hire me
stop.
another attorney.
Oh, no, just 1 second. Let me ask you this.
Yes, Judge,
Are you appointed or retained?
appointed.
All right, you're appointed. So what that means is that the government, the state of Texas, the taxpayers, because you can't afford an attorney, had this attorney appointed to represent you.
Right.
So this is your attorney. If you want another,
Mr.
if
Bernal.
you want another attorney,
Yes.
then you need to hire one.
How?
I have no idea. All
You
right.
don't have no idea.
Judge, may I present the case?
I'm telling you
May I go
how.
forward and try to represent him? He has,
No, you
I
will
think
find me
he's upset.
another lawyer.
I think he's upset, and it's possible that I mentioned before, he's very knowledgeable. He knows a lot of the law. It's old law. I've tried to update him on some of the laws, on some of the charges that he has had in the past, and the charge we're talking about today, which is burglary of the building. I
It's a
explained the
repeat.
different. I explained the
The
difference.
time I was here before,
Mr. Bernal, can you-
no, I need to explain.
So what I
It
would
was
like
the
to do right
same
now.
thing, burglary of a building, and it was dismissed. And
Yes.
now it's a repeater.
Let me ask you something, Mr. Bernal.
Yes,
You're Raphael Bernal?
Yeah.
What do you want to say?
I just said it.
No, what do you want to say? We're here to listen because you keep interrupting your counsel. So nobody's going to say anything. I'm going to let you speak. What is it that you want me to know?
What did you not hear?
I didn't hear any of it.
Why not? Everybody heard.
No, they did not.
You didn't hear it.
No, they said they did not. So what is it you hear?
Mr. Judge, can we get a second, please? I'm sorry.
No, that's okay. Sometimes, counsel, I understand where you are, but sometimes when people don't get their way, they behave childlike, which is fine.
I'm
So
not
this is what's
I'm
going to
64 years
Counsel-
old. I'm older than you.
counsel this. Well, you assume that. Counsel,
What do you
this
mean I assume that?
counsel, this is what's going to end up happening. You're going to go to jury trial. You will be his attorney. If he doesn't want to take your advice or listen to you, then he doesn't take your advice or listen to you. But people need to realize that when you're appointed, people need to realize that when you're appointed an
She's
attorney,
working against me. You're working against me. The district attorney is working against me, and you're not listening to me.
Yeah.
And everybody hears me. Hey, look, now they're gonna assault me.
We're not assaulting you, just.
Yeah, you don't need to do that.
thank you.
You're welcome. So the bottom case number is one that only shows up as being sentenced to. The top two need to be concurrent with it.
Thank you.
I'm sorry about that.
Hey, here's the thing. You know what I always say?
It's one of those days.
No, it's mine, but
Well, even for me too. My
there's a
short
song
errand.
by Monica, just one of them days. But here's my whole thing. Everybody needs to stop apologizing for other people's action. That's a grown man. There's no need for you to apologize for him.
It offends us to see that.
Sorry,
It
Judge.
does.
So bad.
Don't feel bad. That's not you. Cornelius, you know what my grandmother would always say? I don't know why you're feeling bad. That's not you.
I'm like, can you please stop it? Oh my God.
Oh, wow. I don't think this is the first time we've ever heard the word BS.
I didn't expect that. I'm sorry.
Yeah.
I did not expect that.
Cornelius, you know what that reminded me of? Do you remember that movie Injustice for All?
Yes. You're out of order.
We're gonna come back on September 9th for jury trial.
Okay.
Thank you for your patience.
Thank you for your Judge. I apologize. I know just all of it.
No, do not feel bad for other people's actions. And there's no need to apologize.
Okay, Judge, I got that down, and I have one more, but I'll step out.
Offense and pass interference on the defense. Yes. Family line speaks, you know,
Yes.
now you can go. I'll see you all, I guess, next.